So for everybody's information, we're delaying the meeting a little bit. There's been some additional information submitted just here 10 minutes ago, and I'm giving the council an opportunity to read it.
Does everyone online have it?
So some additional information has been submitted to the Planning Commission just within the last 10 minutes. It's a few pages long, so I'm giving the Planning Commission an opportunity to read it so they understand it. We have 3 commission members online. Two commission members online, Les and Aaron. Robert, is there any way you can email what's been sent to Les and Aaron so they can review it?
I don't have any of the new exhibits.
Okay, there's no way to scan them in.
So we'd probably be able to do that.
You could read them in.
Can we ask Bill what our duty is to read these 5 minutes before a meeting?
That's a great question.
Is there a duty to even read these, Bill?
So, the purpose of holding a hearing is to allow people to bring you information, arguments, and otherwise inform you of their thoughts. You know, in the same way that you may be thinking something else while that person is talking to you, you know, the expectation is that you read the materials. So is there a duty to do it? There's a duty to make the decision informed by all the evidence and information in the record. It's a lot easier to do that if you have read it, but if in fact there isn't an opportunity to, then you know that is where we are. I don't know if that helps or confuses things more.
Well, what about the idea of having whoever submitted this in, I can't read it into the record for the benefit of those online, for the benefit of all parties. I haven't read it. I don't know whether it's for a proponent, opponent. But
That's certainly something that could be helpful and could be useful, you know, depending on what it is. If it's a relatively short letter, that's one thing. If it's, you know, a 20-page letter, that's a different kettle of fish.
appears to be 2 pages with a map of some sort.
Yeah, so that seems doable.
Well, couldn't they just summarize what they indicate that they submitted a letter, and if they want to summarize it as part of that, that's the moment?
Yes.
So for the benefit of those online and all parties involved, I think what we'll do is whomever submitted this letter, it was submitted 10 minutes ago. It is titled Appeal Item 1.
So Tesla will
Ask you to read in or summarize the important.
Sir, what was your name?
Evan,
Okay, that Evan is the one who submitted the letter.
Mr. Townsend, Jeremy Townsend, you want something like construction, those are only his talking points. He's going to address the council.
Hey, Mike.
I've heard about half of it. I'm sorry.
Okay, thanks.
Jeremy Townsend, the owner of Sunset Lake Construction, is going to address the council, and those are his talking points.
Thanks.
I got you. And he is going to address the council.
Oh, man.
And these are his talking. Okay. I don't know that we have. I think there is some time constraint. This more that was just submitted? Oh, yeah. Come on.
They can summarize.
There is another packet submitted at 5:54. It has a map on the front. Is that also from Mr.?
It's from me,
That's from you, Stacey.
just some things that I'll be talking about.
Okay. Would it be fair to have you summarize what's in here? Or,
When I speak, I will.
okay, okay. Why don't we come back to this? There's too much information for us to read before we get this meeting started on time, and we can decide more formally how we want to go. How's that sound? the idea here is that we come back to these additional documents that have been submitted and discuss how to have them presented to us. We have not read them. And in fairness to all parties, want to make sure that we understand what's in these packets. Summarize them for us and tell us what they believe is most important, whether through their talking points or just bringing them, holding up and reading in information. Or we may decide we actually have to read it all in, but let's come back to that decision when we get to that point. We're kind of ahead of ourselves here in any other way than to say we don't have time to read all this. Okay, let's begin our meeting here for our planning commission meeting this Thursday, January 23rd. Okay, I'll call the meeting to order. May I have an approval of the agenda for this evening?
So moved.
Seconded.
Is there any discussion? Okay. Tessa, will you call the roll, please?
Commissioner Bates,
Yes.
Commissioner Waite. Commissioner Matusek,
Yes.
Commissioner Sinclair,
Yes.
Commissioner Moritz,
Yes.
Commissioner Orloff,
Yes.
Chair Newton.
Yes. And the reason for my hesitation in asking you to call the roll was I realized that we have a new member here. And I was blindsiding you into your first vote without really just talking at all. One, introducing our newest member, and two, talking a little bit about some protocols. So our newest planning commission member, Steve Waite, thank you for joining us here and taking on these items that come before us. We talked a little bit before the meeting. Steve loves, as we all do, given the time commitment we've all made, this community. Grew up around here on the coast. He's proud to be back here. Has a background in you told me in environmental consulting. You worked in the transportation industry and is currently the vice chair of the Public Works Committee. So we're lucky to have you on board.
Thank you. It's an
Thank you for
honor.
volunteering to join and being appointed. So now that you've been welcomed in and officially anointed, let's get on with the meeting. You have been on many committees, or at least on the Public Works Committee. You're somewhat familiar. If at any point you have a question about any of these protocols, let us know. And maybe you and I can get together afterward, if I'm still the chair after the meeting, and talk a little about some information that was given to me when I first joined and might be helpful to you in terms of just understanding how we operate.
I'd appreciate that.
All right, so let's move on to consideration of minutes. I'll just spend 1 minute with Steve on this. What we talked about in looking at minutes is these meetings are recorded. Information, if someone needs to go back and look at it, is online for them. If there's something about the minutes that you believe needs to be corrected, we then would come to it. But we're pretty quick with the approval of the minutes these days, given the electronic world. So I ask if there are any amendments to the minutes. Does anyone have any amendments to the minutes? No one online? No? Okay. May I have a motion to approve the minutes then?
Motion to approve.
Is there a second?
Second.
Any further discussion? Okay, Tessa, will you call the roll, please?
Commissioner Moritz,
Yes.
Commissioner Bates,
Yes.
Commissioner Sinclair,
Yes.
Commissioner Waite,
Yes.
Commissioner Matusek,
Yes.
Commissioner Orloff,
Yes.
Chair Newton.
Yes. We move next into the public comment section of our meeting. This is time for people to bring forward issues they believe in the purview of the planning commission. We do ask you to keep them within the purview of the planning commission. If you're here on behalf of a specific item, or the only item tonight, you will have an opportunity to speak then. Probably not at this portion, but if there's something else you'd like the planning commission to consider as we consider planning and goals for the city, please come forward. And I see a hand already. Yes, please come forward. We do ask that you limit your testimony to 3 minutes.
Thought it was on the agenda tonight and it's not. So, Elena Junior, PO Box 12. So I'm here because I understand that the city is once again considering a FAR reduction. Something they tried 20 years ago, 20. And I just want to go on record in saying that I think is a terrible idea that I feel that is a to scrunch the FAR from 0.6 to 0.35 limit the size of a home, including the garage, to 1,750 square feet. When they tried this over 20 years ago, they did it. They passed it from 0.6 to 0.5. And then we got a new council and they changed it back to where it was. I would tell you that I've talked to a number of longtime residents who had no idea that this was even in the works. I actually had heard this was happening in 2022 because I sent a letter into the city opposing it then. And at that point, there was chitter chatter about a 2,000 square foot limit on homes and a 17-foot height restriction put forward by somebody. So that's what the chatter was then. Now they're talking about reducing the FAR to 3.5, but allowing you up to 5.5 if you build 2 structures. Sounds like they're trying to get the citizens to solve the housing problem. We had an apartment complex here that was built, again, a number of years ago to assist with the housing problem for locals. And the city allowed that to be turned into condominiums and sold privately, Cannon Ridge condos. So I just want to go on record in saying that I personally think it's a horrible idea. I have talked to many locals who think it's a terrible idea. Folks who own vacant land here, you will cut their values in half. I'm sure that they will all rally together and sue the city if the city makes these changes. I'm also against the new tree ordinance, but I know that's passed your hands now and is up to the city council. But a lot of these things are happening and the locals were not aware. I mean, I live here. I'm barely caught up of these things. I seriously talked to 15 people at the blood drive on Monday about this FAR issue, and they were flabbergasted. They had no idea that this kind of chitter chatter is happening in the city, that the city's contemplating doing these things. So I would just say that I think the changing of the FAR is a terrible idea. It was tried and it failed. And I would encourage you to not go down that route again. Thank you.
Thank you. Does anyone else have public comment they believe is within the purview of the planning commission they'd like to share at this time? Anyone online, Robert? No. Okay. Well, we'll move to our next item. This is the first meeting of the new year. It's the election of our officers. Oh, and introduction of new commissioner. Leave it to me to jump the gun. So sorry, Steve, I didn't do this in order here. So the first nomination is for chair. Is there anyone who would like to, feels like they'd like to be chair, or is there someone who would like to make a nomination for chair?
I think you're doing a great job and I would like to nominate Lee Newton for chair.
Thank you, Mickey. Yeah.
I second that.
Is there anyone else who would like to be considered for chair, or would like to add to this discussion?
Fade Newton for chair.
Okay. Tessa, will you call the roll, please?
Commissioner Matusik,
Yes.
Commissioner Orloff,
Yes.
Commissioner Moritz,
Yes.
Commissioner Wade,
Yes.
Commissioner Bates.
Yes.
Commissioner Sinclair,
Yes.
Chair Newton.
Seeing a note here, I'm going to abstain from voting for myself. It feels odd, but it looks like I did win. And
Or no.
or not.
Yeah, do you call that winning or not?
Thanks, guys. Okay, we'll move on to the nomination for vice chair. Is there a nomination for vice chair?
Yes, I nominate Ann Moritz. Second.
Is there anyone else who would like to be considered or add to this conversation? Okay, then Tessa, will you call the roll, please?
Commissioner Orloff,
Yes.
Commissioner Bates,
Yes.
Commissioner Matusik,
Yes.
Commissioner Sinclair,
Yes.
Commissioner Moritz,
I'll abstain.
Commissioner Wade,
Yes.
Chair Newton.
Yes, congratulations. Okay, we'll move to our next item, a quasi judicial hearing. AA 24-01, Stacy Benefield for an administrative appeal of development permit 24-50. AA 2401 Stacy Benefield for an administrative appeal of the city's approval of a development permit, DP 2450, for the construction of a fence curb retaining wall at 716 North Laurel Street, tax lot 5800, map 51019 AA. The appeal will be reviewed pursuant to the Cannon Beach Municipal Code, section 17.18, request for review of decision. Does anyone object to the jurisdiction of the planning commission to hear this matter at this time? Double checking. Does any commission member believe he or she has a conflict of interest or personal bias?
I don't believe that I have a conflict of interest or personal bias, but I will say I was in the notification area for the appeal, not for the original permit. But we live far above, and I don't think that our property is in any way, shape, or form affected.
Okay, the chair is last to go on this question. So Bill, any comments so far? I don't see anything. Okay, so
He's,
there,
Bill's
I read your
muted.
lips no, but I didn't hear no.
Yeah, sorry, I thought I hit mute off, took the mute off, but I didn't. But yeah, I haven't heard anything that is
Okay.
problematic, but you want to make sure people have an opportunity to object.
Sure. It was voiced in writing. You all probably read an objection to me remaining chair. And for not the reasons that were voiced, but other reasons, including my property sits adjacent to this property. And there potentially could be a financial impact to me if there were water flowing on my property. I am going to recuse myself from this and you will be the chair.
And I've had, I had a site visit and, I mean, I'm certainly no substantive ex parte contact, but I was informed by one of the parties of tonight's hearing just in passing, but didn't talk about the merits or any substance of the case. So I don't feel any bias in any way.
I'll add, I've had ex parte communication 2 years ago, but not in regards to this specific issue that's at hand.
I have nothing to say. You guys waited till, I'm off, so I'm out.
Done.
So I'll leave it to you.
I'll
Good
take
luck.
your instructions over here.
Did I think, I thought I left it.
I have an extra one if you need.
No, I have it.
Getting away with the instructions.
Yeah, I was really trying to trick you.
Great,
Good luck.
thanks.
and I did a site visit during which time I spoke with I spoke with the respondent for permission to get on the property and then with the appellant to see the rear of the property to see where this creek originated, but that was it.
All right,
I've had a site visit also, but I didn't speak with anyone while I was there.
do we have any objections to those remaining on the commission? Okay. Let's move forward with the staff report, please.
Good evening. The appellant, Stacy Benefield, is appealing the administrative decision to approve a development permit DP 2450 that was issued December 5th, 2024. For the purpose of placing a fence curb / retaining wall along the northern property line of 716 North Laurel Street. On November 25th, 2024, City Code Enforcement and Community Development staff visited the subject property in response to a code enforcement complaint. During this visit, city staff made contact with persons working on the property, informed them that permits were required for the type of work being performed, and issued a verbal stop work order until such a time that permits were obtained. On November 26, 2024, Jeremy Townsend of Sunset Lake Construction applied for a type 2 development permit for a fence curb measuring approximately 53 feet in length that would extend 2 feet below grade. The permit was issued on December 5th, 2024. The city received the notice of appeal on December 16th, where it was stamped, paid, and received by the city on the same date within the 14 consecutive day appeal period. The appeal is based on the following arguments. Argument number 1, the appeal relies on a stream corridor map that fails to accurately represent the location of a mapped stream and thereby fails to prove the proposed curb is not within the buffer of a mapped stream in direct violation of 17.116 stream corridor and protection. The staff comment is the appellant argues that mapping information used by the city and its decision-making is incorrect and refers to an online copy of the local wetland inventory. For a moment, while I bring the mapping, how it refers to okay, this is the map that is referred to by the appellant in the appeal documents. That is included in the staff report as figure 1. GIS mapping through GIS mapping for local wetland inventory site number 18 at the time showed it terminating at the approximate center of 716 North Laurel Street. This is shown in the figure on the screen currently. The city's GIS information appears to be based on a paper map that was produced for the city's local wetland inventory, an excerpt of which is shown in this image below, which in this particular image shows site 18 truncating toward the top of the page, approximately in the middle of the subject property. Argument number 2. The application does nothing to address how the proposed structure will impact drainage patterns, specifically how it will affect neighboring properties in direct violation of 1792 grading, erosion, and sedimentation control. The staff comment. On December 3rd, the owner of the subject property sent an email to the city's code enforcement officer, included as Exhibit A2, in which she stated that the project is exempt from permitting requirements under Municipal Code 17-12-020, exclusions from development permit requirements. The city staff does not concur with this interpretation of the code, as Municipal Code 17-92-020A1A, which details requirements for grading and erosion control permits, states, quote, the proposed clearing, grading, filling, and excavation is located within 100 feet of a stream corridor or a stream, watercourse, or wetland, close quote. Based on all available information, the subject property and proposed work area is within 100 feet of LWI Site 18. Project schematics indicate that an existing culvert on the northern property line will be retained. Prior to the issuance of DP 24-50, the project's contractor provided clarification to city staff regarding the status of the culvert and plans to retain it. Argument number 3, the application fails to demonstrate that the curb will not cause overflow water to drain on the property of another indirect violation of 804-140 surface water drainage. Staff comment is that this criteria was not evaluated, as the proposed project does not involve removal of an existing culvert. And that concludes the staff report.
I know that our Public Works Department also had some information that was included in your packets this evening, and there was a staff report, and I was wondering it might not be a bad idea to allow Director Karen Labonte to have the opportunity to present that staff report as well.
I think that would be very helpful. Thank you.
There's, Public Works does not work on private property. But our concern with this particular case, I think I summarized in the staff report, kind of the history associated with this area. And the homeowners in your staff report, there is a very extensive view that the city, an independent engineering firm that has the as well wetland expertise. They did a complete evaluation of this area and the surrounding storm infrastructure that the city has. The gap in this report was the path of the flow of water that is in the private party that we're talking about, private property of Miss Logan. So it is unknown the current condition of that path of water flow, which meets our city infrastructure and goes on to the wetland area. So it is unknown the condition. Any maintenance is unknown. Any obstruction, if it's been even checked that there's any kind of obstruction in that path of water flow. I think that is crucial for us to know to really make a final assessment of that surrounding area. It's not appropriate for the city to take any action without knowing that. The engineering firm can't even make recommendations to us without knowing that information. And it's important for the city to understand the potential impact to water flow associated with the proposed construction. I have to be prepared to receive that water and get that water navigated where it needs to go. I have no idea what the impact of this could be. I can speculate, but I don't know. So that's what Public Works is. That's our only dog in the fight, is that we just need that information so that we're prepared, should you allow this to go forward, that we can manage that water, and prepared for any other private property owner that could be impacted by that and the city's having to receive that water and take it somewhere. So that would be my only request of you, is the importance of that information.
Question, does the city even, how deep is the report that was done? Were they even able to obtain that information?
We don't have any information relative to the path that's on that private property. We could only do anything in that surrounding area that is city's own property. The adjacent homeowner did allow us to go on their property to look at that culvert, see if there was any obstruction that could be contributing to how that water's coming off the hill. That's the limitation of what we were able to do. Hearing from.
You end at the property line.
Right.
But you're allowed to the properties on the north and the south, or north?
Just the north.
Okay.
Karen, did you say that the culvert now connects with the city's water system, stormwater system?
Which culvert are you talking about?
The culvert on the private property you were referring to?
It goes through Miss Logan's property and connects to our property from there, our right of way.
Next to the property, but not to the system, not the pipeline. There's a gap and the water runs freely then and then into the city system.
Right, so as you see in the map that was included, that goes from the culvert on the northern property, the Benefields, through the path of Miss Logan's and meets our city right-of-way storm system and goes on to the wetlands.
Okay, thank you.
Okay.
I saw a reference, it's called a private culvert. Is there any idea if that culvert was put there or why or when? Karen, anywhere in the records?
You know, I'll be honest with you. I mean, it's been there for a very long time. The why, I could only speculate that that intersection as a whole receives a magnitude of water from various locations that comes down through our infrastructure and goes on to that wetland. So that area receives quite a volume of water. Any other questions? Thank you much. Let me weigh in.
So the next question is additional correspondence. I believe we do have up to the minute correspondence received.
Yeah, you all received a packet and then received the letters that we.
The most recent. There was a brief discussion earlier about the fact that we do have some very late additions to the record. I am suggesting that the best way to move forward would be that the individuals who provided this plan to address it in oral argument in your in what you present today so that you can tell us what's important and make sure you summarize what you want us to know from this. At this time, I will be calling for public testimony. The pertinent criteria to be considered are noted in staff reports and listed on the criteria sheets, the meeting page of the city's website. Testimony, arguments, and evidence must be directed toward those criteria or other criteria in the comprehensive plan or a municipal code which the person testifying believes to apply to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes appeal based on that issue. Prior to the conclusion of the initial evidentiary hearing, any participant may request an opportunity to present testimony, arguments, or evidence regarding the application. The Planning Commission requests by continuing the public hearing or leaving the record open for additional written testimony, arguments, or evidence. Persons who testify shall first receive recognition from the chair, state their full name and mailing address, and if appearing in a representative capacity, identify whom they represent. I'm going to talk about terminology here briefly. I will be discussing applicant, proponents, opponents. Applicant in this case is the person bringing the appeal, and opponents would be the person who is defending against that appeal. Is there a presentation by the applicant?
Stacy Benefield, mailbox 1424, Cannon East. Good evening, commissioners. Time and dedication to the city. Thank you to city staff for all the hard work. For the nearly 20 years we have been in Cannon Beach, we have stewarded and enjoyed the beautiful stream that flows through our property. Several times a year, we walk the stream bed, clear any debris, and notice that if there are any changes. In the rainy season, we check frequently to make sure the culvert opening is clear and that water is flowing freely. It is very important to us to maintain the integrity of this and its natural course. In my years in Cannon Beach, I've been involved in environmental efforts, including the Friends of Hazel, South Board, Cannon Beach, and others. I'm also the recipient of the Gaylord Nelson Award. On the surface, the matter before you appears to be about a fence. If this issue were just a matter of replacing an existing fence, I would not have filed this appeal. I'm appealing DP 2450 for the construction of a dike in a stream buffer. This steel reinforced concrete structure will be 53 feet long, 3.5 feet high, which will be underground, 1.5 feet above ground, and 1 foot wide. This is not merely a curb for a fence. This is a dike. There is a potential for the proposed project to direct added stormwater onto the adjoining property to the north and very likely to the east and west. For this application to have been approved, an analysis of stormwater flows should have been conducted by a qualified individual that shows the permitted project's impact to adjoining properties created by restricting, diverting the natural drainage pattern of water. It is very concerning that we know nothing about the condition of the culvert and catch basin on subject property. I did a public records request to the City of Cannon Beach, the Oregon Department of State Lands, and the Army Corps of Engineers. I have submitted the documentation for the record. That's some of the stuff I there is no record of any permits being issued for the culvert or catch basin on this property. We did not know when it was constructed or if there was any engineering study performed prior to installation. Because they are on private property and maintenance is the responsibility of the property owner, we have no assurance of the integrity of these structures. It is not known if the culvert has been properly maintained. What if the culvert or catch basin get plugged or partially plugged? What if the culvert collapses? With the dike in place, the natural flow of stormwater will be altered. I'm appealing Order 2450 on the following grounds. Number one, the application does nothing to address how the proposed structure will impact drainage patterns, specifically how it will affect neighboring properties in direct violation of 17.92 grading, erosion, and sedimentation control. Number two, the application fails to demonstrate the structure will not cause culvert overflow water to drain onto the property of another, a direct violation of 8.04.140, surface waters drainage. Number 3, the approval relies on a stream corridor map that fails to accurately represent the location of a map stream and thereby fails to prove the proposed structure is not within the buffer of the map stream, direct violation of 17.116 stream corridor protection. I have a few photos and videos to share with you to give you an idea of the terrain. Thank you, Robert. See, this is a close view of the fence and culvert. And where you see the fence, that'll be close what the structure would be. This is a view looking north as the stream enters my property. This photo shows the stream as it leaves our property and enters the culvert on subject property. The stream then flows through a culvert on subject property into the city's stormwater system and into the wetland at 7th Street and Laurel Street. It then flows through the north end of Cannon Beach and into Logan Creek. I've included a map from the Cannon Beach local wetland inventory. I sent that in yesterday, showing its course. The proposed dike is where you see the fence in the photograph. I also have 2 videos to share with you. The day before a big storm and one during the storm. So this video was taken December 4th, 2023. Stream is flowing freely into the culvert. Short video. The next video was taken the next day on December 5th, 2023. As you can see, the water has backed up onto our property. The rainfall total that day was 4.28 inches, which is an excessive amount of water. Thank you very much. Where will this water go if there's a 1.5 foot high by 1 foot wide, 53 foot long concrete dike blocking the water? Currently, this backed up water flows onto subject property under the fence. With the dike in place, the water will be diverted elsewhere onto adjacent properties. It will back up even further onto my property and will be diverted onto other properties as well. This is in direct violation of section 17.92.0303A, grading, erosion, which states proposed grading shall not alter drainage patterns so that additional stormwater is directed onto the adjoining property. This code alone is sufficient grounds to deny DP 2450. The project does also not meet the following standards: 8.04 nuisances and section 8.04.140 surface waters drainage. The code states that no owner or person in charge of a property shall allow overflow water to drain onto the property of another, as this would create a nuisance. The proposed structure along the north side of the subject lot, in conjunction with the existing house foundation, will restrict the flow of stormwater overflow from its natural path and divert it toward the street and adjacent properties. And therefore, the permit as approved will allow surface waters to drain onto the property of another, which violates this section of the code. In addition, this project does not meet the standards in chapter 17.116, stream corridor protection, because building what is described in the application as a fence curb or retaining wall, but effectively will act as a dike in a stream corridor, will not allow the stream or stormwater to maintain its natural course. In excessive rain events or potential culvert blockage, the stream will seek alternative flow routes. The proposed project is clearly within 10 feet of the bank. It will have a concrete structure over, under, and on both sides of the culverted stream. Construction of a retaining wall dike across a stream is not a permitted use or activity as listed in the code. The Stream Corridor Protection Code requires an applicant to consider less impactful alternatives to the proposed project, and a permit from the Oregon Department of State Lands required under ORS 227.350. And the Army Corps of Engineers must be applied for prior to any excavation activity in protected waters of the state. So one of those documents that I submitted to you is ORS 227.350. It also includes the information about what is required for notifying the state when a complete development permit has been submitted to the state. And that the requirement is that a wetland land use notification be submitted. That information is in there as well. The applicant's filing did not include any of this information. This stream is in the statewide wetlands information. In that map, you'll see it's an identified stream, which I saw. Furthermore, an erosion control plan to protect the stream and adjacent upland areas from erosion and siltation was not submitted. Approximately 5 feet north of the proposed structure is an open stream, which certainly is impacted. I'm asking you to uphold AA 24-01 and deny DP 2450 for the construction of a dike in a stream buffer, which will likely alter the natural flow of water and more than likely cause increased flooding on our property and divert the flow of water onto other properties in the neighborhood. Thank you.
I will now call for other presentations by proponents. That would be those supporting the appeal. Please come forward.
Hi, Diana Turner, PO Box 211, Cannon Beach. I sent something in last night, but I guess there were some email bugaboos and it wasn't received until late this morning. And I'm not sure that you guys had a chance to read it. So I wanted to check in with you guys and see if you did receive it and have a chance to read it. If not, it's just a couple pages and I'll read it now.
You read it, please, into the record.
Sure.
You did receive it.
Yeah.
Okay. Go ahead and read it. Dear planning commissioners, and I have copies for you guys because there are a couple of.
We do have copies in the packet that we just received.
Does anyone need a copy right now? Can I pass it? Okay. Dear planning commissioners, I'm writing in support of appeal AA 24-01 of the administrative approval of permit DP 2450 to install a cement dike on the property line between 716 Laurel Street and the adjacent undeveloped lot to the immediate north. Though the applicant asserts they seek to install a landscape curb or a fence, this is disingenuous. To demonstrate that, the applicant is actually seeking to install a dike to redirect water away from their property and thereby onto neighboring property. I'd like to share the conversation I had with Ms. Logan's contractor on November 25th, 2024. Around 7 a.m. that morning, 4 workers began construction work in Ms. Logan's backyard. Because I worked from home and had a Zoom meeting scheduled, I was concerned the noise from this construction work might be too much to remain working from home. So I went outside and introduced myself to the workers and asked what noise level they anticipated making and how long they would be working at the location. The workers referred me to their supervisor who'd just shown up with a trailer hauling a backhoe vehicle. This gentleman explained they would be building a cement curbed fence. First, he said they would use the backhoe to excavate a trench along the property line, then insert wood forms that would be filled with concrete. I'm sure I looked puzzled because I didn't understand then why a cement curb was needed to replace the current plain old wood fence. I asked, quote, "You're building a cement fence?" He said, "No, it'll be like a retaining wall." Still puzzled me, and then he added, "to act like a dike." Though I admit I still did not understand exactly what was being constructed, we returned to the issue of how loud the work would be. He was very polite, answered my questions, and I thanked him. As the excavation work continued and a large wooden form was placed, the pictures attached, my concern grew regarding the unexamined consequences for Stream 18, a tributary of Logan Creek, which runs through Ms. Logan's property and adjacent to my property, and a non-permitted, decades-old, small 18-inch culvert, plastic culvert. If the water is stopped by the dike as intended, where will it go? Who then of us neighbors will inherit Ms. Logan's problem? Ms. Logan purchased a low-lying piece of land that occasionally floods during times of exceptional rainfall. This was disclosed to her by numerous people prior to purchase and was, in my opinion, reflected in her low purchase price. While it appears Ms. Logan is now unhappy with the reality of her low-lying property, it is unreasonable to allow the construction of a cement dike on top of an old plastic culvert, shifting her problem to the Stream 18 wetland corridor and her neighbors. Until the applicant provides an analysis by a hydro engineer and the appropriate state agencies, including this concrete dike, built on top of a plastic culvert stream in number 18 will not, number one, redirect water onto neighboring property. This application must be denied per CBCC 17.92, grading, erosion, and sedimentation control, and CBCC 8.03.140, surface water drainage. 2, will not be within the wetland buffer zone. This application must be denied per CBCC 17.116, stream corridor and protection. Will not negatively impact Stream 18 and the flora and fauna who rely on it. This application must be denied per CBCC 17.116, stream corridor protection. This project cannot be approved as it is before you today. Please endorse this appeal, reversing the administrative approval of DP 24-. And then, Mike, I just have a little bit of knowledge to add to your question about the culvert. So we own the home next to Ms. Logan's to the south. Our house was built in 71. And during the purchase process, we spoke to the nephew of the elderly lady who was selling, who we were buying from. And he told stories of an open creek that ran through Ms. Logan's property and adjacent to ours, and talked about that he and his siblings had played in that open creek. And then one day, the people who owned Ms. Logan's property prior to her culverted it. So this isn't a lot of information, but at least we know that it happened after 71.
Yeah.
So.
Thank you.
Thank you.
Are there other presentations by? Please come forward.
Hello, my name is Clay Newton. My mailing address is PO Box 211, Cannon Beach, 97110. My wife and I own a house at 324 7th Street, which, as she mentioned, is adjacent to Ms. Logan. While attempting to address some of the maligning comments that have been put in the public record, I'm not going to do that. I don't believe it would be helpful or useful to you in making a decision. I'm also not going to dive into the code, which I think is addressed by the testimony you have in the record. But I would like to share a unique perspective for your consideration when thinking about this. My wife and I have owned the property at 3247 since 2008. In that time, joining us, the property we're discussing tonight has had 4 different ownerships. There have been several flood events during that time that we've owned the property. To our knowledge, it has never been reported to us that the flooding has gotten into the living area of Ms. Logan's property, but there have been some pretty extensive floods into the yard. So one day, in the late spring, maybe early summer, I was in my yard and Ms. Logan came up and introduced herself to me, the prospective purchaser, how she now owns. She asked me a lot of the types of questions one would expect to a person buying a home. Did we like the area? What was it like in the summer? But she also asked me a question that was not, caught me a little off guard. She asked me what I knew about the flooding next door. And it was a tough question because I could see it was an upsetting question for her. It's an upsetting thing she was considering. But it was also something that we had heard before from other buyers. I knew it was a difficult situation for my neighbor who was having trouble selling the house. But I shared with her what I just shared with you. This is exactly what I knew about it. It had flooded many times, but in somewhat of an massage to maybe alleviate some of the anxiety, I said, but we had never known about it getting into a living area. We talked for a little bit more, and then Miss Logan went her way. And I remember going in and telling my wife I just had a tough conversation. It was tough because I felt like I possibly was deflating someone's dream of owning in Cannon Beach, and we all know it's a beautiful place to live. And I didn't feel good about it, but I also wouldn't have felt good about saying anything but what I knew. And I also felt bad for my neighbor who was trying to sell her house. She was having a really hard time doing that. Sell her house. So one thing that's very clear to me is it has always been clear to Ms. Logan that she's had a flooding issue. I was told that she dropped out of contract shortly after our conversation. I never knew why. I could make assumptions, but I never knew. Several months later, I was told she was back in contract and that she actually closed on the property. Again, I could make assumptions about back or and purchase the property, but again, I never knew for sure. What I can tell you unequivocally, she did know that the property flooded. She knew because I told her, and she knew because she asked the question she did, even if she doesn't remember our conversation, which sometimes happens. There's no way she didn't know based on the conversation she had. And it's reasonable to expect that she was told by a real estate agent. That's a pretty big disclosure. If your client knows that their property floods, they have to disclose that as a part of the sale process. It could have been disclosed in an inspection report that she had done. I don't know. It could have been disclosed by other people who looked at the property. I'll never really know anything other than she knew it flooded. But to come before you today and put the record that we have in terms of the testimony that says that this is a landscaping curb, and it is not really what it is, which is a dike to redirect flooding stormwater off of her property onto another, is disingenuous. And I'll ask you to uphold the appeal, Ms. Benefield has before you tonight. Thank you.
Are there presentations by other proponents? At this time, I will ask, are there presentations by opponents?
I believe, sorry, I'm the protocol. I apologize. I'm Susan Logan, PO Box 484. I'm the property owner. I know that my contractor has more to speak about than I do. And I would like to share a little bit more later, but I have to just respond to what was said. I do remember a conversation with Clay Newton when I was considering purchasing this house. I knew that there was a culvert that ran somewhere in the backyard. I knew that I needed to do my due diligence, and I contacted the county and asked them the situation with that. I was told that there was water from somewhere up the hill, and there's culverts all over the north end of Cannon Beach. And I was scared about that, so I asked everybody I could if there was a big problem there. Clay Newton never told me that that house flooded or the yard flooded. And it was never disclosed in anything I read that the house flooded on a regular basis. In addition, so nothing was in my disclosures about that. I don't know why the previous property owner would have purchased the house and owned it for 8 years if she knew anything about that. And I didn't pray some kind of a low-lying flooding property, low payment for my house either. At the time of my purchase, I was considering either that cottage or a condo at Breaker Point, and they were the same price. So I made my choice for the cottage that I fell in love with. I am diagnosed with generalized anxiety disorder, And had I known that I was purchasing a house that was going to be flooding on a regular basis, that would not have been something I would have chosen to do. I wanted to also clarify for Mr. Waite, you had asked Ms. Labonte if the culvert continues from my property out to the street. And it does, it's continual. There is no break in the culvert between Mrs. Benefield's property and the corner of the street. And I would like to also reiterate that that culvert begins on Mrs. Benefield's property, not my property. So all I knew when I bought my house was that there happened to be some culvert from somewhere up the hill that went across my property and onward down the hill. And North Cannon Beach is full of culverts, and that's what I knew. Thank you.
Do we have other presentations by opponents?
Yes, we do have Ms. Logan's contractor.
Thank you.
What is his name? It's the J.
What's your contractor's name?
Mr. Townsend.
He be under the name Tracy Rocky?
Tracy is with Jen.
Okay.
Yes, can you guys hear me now?
Yes.
All right, thank you. Hi. Good evening. My name is Jeremy Townsend. My address is 89187 Mannion Drive, Warrenton, Oregon, 97146. I am the owner of Sunset Lake Construction. I'm in a contract with Miss Logan to get rid of this fence curb and to do a new fence with her. We're here to appeal the we're here fighting the appeal. We believe the project should be allowed to proceed. A couple reasons. And appeal item 1, and I apologize for getting these to you guys late. I was just told that they needed to be for the record. So we did this permit and the plan per the maps that were available to the city of Cannon Beach. I've also looked on other maps, and some of them show it going through the property. Others show it not even on her property. If you look at the National Wildlife or the national map, it doesn't even show it going through her property. It goes around the northeast corner of her property. So on this one, it says, I want to talk to the codes. 17.116. It has a 10-foot buffer and a 15-foot buffer. We are actually 2 feet inside of the fence, which I believe will put us outside of that 10-foot buffer. And we're also, that's from the culvert. And the stream, according to the city of Cannon Beach, starts at the catch basin on the south side of Miss Logan's property. And the excavation is 45 feet from there. Also has the permitted stream buffers established. To issue a development permit, they have a list of 6 things there. Nothing we're doing is in that list of requirements. And the biggest thing is we don't need a structural permit or a building permit for a fence per city code because it's going to be less than 6 feet. So that would be the only one on there that we would have to fight. So any change or repair to a building or other structure that does not alter or expand the use of therefore require a building permit, the fence does not require a building permit. So we don't fall under that one. Number 2, the application does nothing to address how the proposed structure will impact drainage patterns. According to the city of Cannon Beach, the stream that is present as number 18 starts on the south side of Miss Logan's property, as we said, and we're 45 from that. The city staff does not concur with the interpretation of this code. The proposed grading, filling, or excavation is located within 100 feet of a stream water course, and that was their argument for me to get the permit. The following items the 1792.020B, the exceptions, are exempt from the requirements of subsection A, which requires us to get a permit. Residential landscaping and gardening activities up to 2,000 feet in area. The area we're disturbing is literally, if we go 53 feet long, I have 55 on here just in case, is 55 square feet, a far cry from the 2,000 square feet that we're allowed without a permit. And then number 3, it fails to demonstrate that the curb will not cause overflow water to drain on the property of another in direct violation of 804-.140. This code doesn't pertain to the curb, as the water will be coming from the neighboring property. It does not originate on Miss Logan's property. And Exhibit A1, that the complainant shows that it's coming from the Benfield's property towards Miss Logan's. So she's not allowing it to flow onto their property. It is already originating there. And I understand there's an ongoing issue between the two neighbors. I'm not trying to get involved with that. I'm just trying to do my job as a contractor. I got the permit, and now we're in this process. They have, so Benefields provided, the map that the Benefields provided shows that the stream originates near Cola Park Road. The map that I have enclosed shows that the stream doesn't actually flow to the property at all. And that was the one I was talking about, the DSL National Wetlands Inventory map that should be included in that packet that my superintendent Evan gave to you guys. And then as I was doing my research for this hearing, I began to wonder about the creek and all the structures built near and around it. I found the Benefield's home is directly over the creek as well. There was an article in the Astorian from when they first moved in on how nice their house was above the creek. Great, I love that. That's a beautiful home. They did a lot of nice work to it. But I was reading that, and I'm assuming they were grandfathered in to be over the creek. So the same courtesy to me should be extended to Miss Logan for the culvert that was placed in her backyard before she bought it. It's an 18-inch culvert. We're not technically going around the culvert. We're going over the top of it because we're only going 2 feet deep. In my opinion, and according to the codes that I've read, if we didn't need the permit, we should not be in this process, but we are. So I want you guys to understand that according to the codes, we should still get to continue with this landscape curb and let her get her fence built. As I understand, part of it has fallen over in this last week. So I also, after I typed this up, on that article that I was reading in the Astorian, when the Benefields redid their house in 2013, they ended up drilling in 7 foot deep piles near the creek to resupport their addition. And I'm sure this is permitted. I don't believe that they would do it without getting permits. But again, if it's good for them, it should be good for their neighbor. So if there's any other questions, I know Miss Logan wanted to talk about some other things, and she can take it from here. She can continue this for now. Thank you for listening, and I appreciate you guys' time and your services.
Thank you.
Can I speak again?
Yes, you may.
My letter has already been circulated to the staff, to the commission. But because there's also been information running around the neighborhood, I would like to go over this argument that was presented and give my interpretation of the facts as they differ. In argument 1 presented in this appeal, I quote, "The approver relies on a stream corridor map that fails to accurately represent the location of a mapped stream and thereby fails to prove The proposed curb is not within the buffer of a mapped stream in direct violation of state border protection. I have to say before I continue that for almost 2 years, I have talked to everyone at the city about the fact that the GIS mapping system in my property is completely false and inaccurate. And I've had nothing but people ignoring me for over 2 years. The second appeal argument is that the application does nothing to address how the proposed structure will impact drainage patterns, specifically how it will affect neighboring properties in direct violation of grading, erosion, and sedimentation control. Dear Planning Commission, the proposed structure is a landscape curve. I will let my contractor address this specifically, but more importantly, I would refer you to the photo which Ms. Benefield has provided for this appeal. That photo represents her property, completely her property. The fence that you see on the left side of that photo represents the legal boundary between our properties. My house is out of view of that photo. As is evident in that picture, flooding has been taking place on the Benefield property, and records of photos taken on additional dates demonstrate additional flooding on their property. I'm not sure I understand why Mrs. Benefield presented this photo, but I'm happy that she did. It represents proof of the flooding which has already occurred on her property and her knowledge of that fact, in addition to the threat of overflow water to neighboring properties, not only my own, but everyone's. Please understand the source of the stormwater which was flooding the Benefield property is located on the hill above them. On that hillside is a deep and massive ravine, which recently has been referred to as Stream 18. I understand this determination comes from an outdated wetland study accomplished over 30 years ago, handwritten with interpretation challenges. Several culverts currently empty into this ravine from both east and west, creating an intermittent waterway that flows during winter and spring. The stormwater traverses down the ravine, collecting sediment, wood debris, boulders, and anything else that goes through the ravine as it flows toward the Benefield lots. The stormwater then flows into a culvert which begins on the Benefield property. And when that access is not maintained properly on her property, the culvert clogs and floods. The city is aware of these factors and they're worth repeating today. Mrs. Benefield's expressed concern for grading, erosion, and sedimentation control has nothing to do with the placement of a landscape curb on my property and everything to do with the circumstances which currently exist on her property. The photo in Exhibit A demonstrates grading, erosion, and sedimentation control issues exist on her property and should be managed. Ms. Benefield's apparent newfound concern for future flooding on her property or neighbor property is already an issue with or without a curb fence, which I propose to construct. In argument 3, the appeal presented states, the application fails to demonstrate the curb will not cause overflow water to drain onto the property of another in direct violation of surface water damage. As just clarified, there is already historic proof of overflow water draining onto the property of another and in direct violation of this code. And this violation has already existed on the Benefield property. No violation, however, has been issued to the Benefields for flooding which occurred on my property as a result of the overflow. Additionally, the city has stated more than once to me that this is a civil matter and not their problem to resolve. Please understand this fact. A landscaped curb to the south of Mrs. Benefield's property will not affect the flow of a culvert. The landscape curb does not enter the culvert. I would additionally like to address Stream Corridor Protection Code to which Ms. Benefield refers in number 1 of her application criteria. And I would also like to state that there is a serious probability that the Cannon Beach mapping delineation of Stream 18 has been inaccurately designated. Given the serious inaccuracies which exist in the city mapping system, this could be expected, and here's why. Additionally, as mentioned, The designation of this stream is based on a 1994 wetland study. As recently as 2018, the Windsor Report commissioned by the City of Cannon Beach to study flooding at 7th and Laurel referred to this same waterway as an unnamed stream. Additionally, the Windsor Report engineers confirmed in their study that Oregon Department of Transportation and Oregon Parks and Rec Department were reached out to provide information on the infrastructure in Ecola State Park and the surrounding areas, and no records were found. The Windsor Report has also warned that the stormwater which traverses down the mountain ravine between Ash Street and Ecola Road and appears to begin at 8th Street is unstable. Section 5.2 soil characteristics of the study reads, and I quote, "Most of the drainage basin is sloped, with slopes ranging from 30% to 80% and small areas of flat. The basin also has a geological hazard overlay and landslide susceptibility, according to the Clatsop County GIS mapping. And yet to this day, the city continues to dismiss this warning, regardless of the historic Ecola Park Road landsliding, which has already occurred." Again, the stream, or more accurately, the floodwater emptying through a variety of culverts into a deep ravine and flowing into a culvert beginning on Miss Benefield's property, is already no longer in its natural state. It's in a culvert. I repeat, the stream is no longer in its natural state beginning on Miss Benefield's property. It's in a culvert. Miss Benefield's acknowledgement of the 10-foot buffer established in this code is curious, since her property is itself in violation of this buffer zone. If there are special circumstances which apply to her property, would those not apply also to my cottage built in 1924? For clarification of facts, my contractor is constructing a landscape curb, not a retaining wall. More importantly, since the stream to which Miss Benefield refers has already been culverted on Miss Benefield's property, there is no stream located on my property through which a constructed curb would be crossing. It is still my contractor's understanding that permits for this curb were not required. For the record, further investigation and legal ramifications will be ascertained for the following code subjects cited in this appeal, including but not limited to buffer zone violations, which have either been ignored or for which special circumstances have been provided as compared to my own property rights. Grading, erosion, and sedimentation control management as may be required for the Benefield property in recognition of the resultant effects of overflow flooding to neighboring property. Surface water damage is applied to any overflow of water which may traverse from the Benefield property to my own or to other neighbors. Ms. Benefield also mentions the Windsor Report and the crucial findings which should be addressed by the city and have not been. The city paid $15,000 for this Windsor Report, and I don't believe that any single recommendation from that report has ever been implemented by the city. The topography of the area, which includes a ravine filled with culverts that send stormwater gushing down an eroding mountain filled with sediment, boulders, and wood debris, is actually not mine to resolve, as Miss Benefield has suggested. The issue of private stormwater systems which have not been fully documented, or public stormwater systems which are several decades old and in drastic need of repair on the north end of Cannon Beach, is also not my responsibility to solve, as Ms. Benefield has suggested. That is the job of the city. And rather than providing that service, believe it or not, Public Works has recently determined to double down on their lack of responsibility for maintaining the North End stormwater system, stating that they will no longer be managing the system, which includes the corner of North Laurel Street and 7th Street. We know that this stream begins somewhere up in the Ecola Park, although there's no direct lineage to where it comes from. And it drains approximately 54 acres of total draining into the 7th and Laurel intersection. And now we have been informed by Public Works that they no longer plan to maintain that intersection. What next will this city ignore? Thank you very much for your time.
Are there other presentations by opponents? Do we have anyone online?
No.
Is there a staff response?
The only response that I'd give is there's been a lot of comments about being ignored. I would tend to say that Mrs. Logan hasn't been ignored. I would tend to say that some of the answers that have been given in terms of the stream itself, I guess there would be a difference in opinion.
Thank you for that. Does the applicant wish to make additional statements?
Thank you very much. In closing, I just wanted to say that this permit violates 17.116 stream corridor protection, 17.92 grading, erosion, and sedimentation control, 8.04 nuisances. I ask that you uphold AA 24-01 and deny DP 2450. Permitting this dike to go forward would set a very bad precedent for the streams and waterways of this city and could negatively impact surrounding property owners.
Question for you.
Yeah.
The assertion was just made that the problem originates on your property, the culvert is placed on your property. I'm assuming you get no benefit from that, do you?
I get no benefit from that. We do try and always keep the culvert area clear. My understanding is that started on our property, but it's not for our property.
Right.
It's for the 716 North Laurel.
So as far as you're concerned, you could cut it off right at the property line and not care, except that, of course, you would change the drainage patterns and you don't want to do that.
That's right.
Okay.
Any other questions? Thank you very much.
We have one more staff comment.
I'd like to just go on record and say that from a public works perspective, we do routine maintenance in that area as we do all of our storm culverts throughout the year, especially preparing for the winter season, following the winter season, going into the dry season. That means visual inspections, sometime inspections of the line themselves to make sure they're not collapsed, there's no obstructions, no one has dumped anything down it to create some sort of an obstruction. Do the same thing on our annual maintenance associated with the wetland. We are allowed at the mouth of the wetland to maintain that area so that any water coming from the storm system meeting that and flowing on down its path is free of obstruction. That is part of our routine maintenance. We continue to do that. I just reached out to two of my lead staff members to verify if there had been any discussion whatsoever regarding Ms. Logan's claim that we no longer maintain that. Neither of them have spoken and neither have I. We wouldn't make a claim such as that because that is city infrastructure and we're responsible for maintaining that on an ongoing basis.
And for clarification, the culvert pipe starts on the Benefield's property, flows under and through subject property.
Correct.
The storm grate on subject property, and it exits at the property east of 7th at the wetland there, correct?
Correct.
Okay. Who is responsible for maintenance of that culvert on private property? Is that the owner or is that the city?
That is the owner's responsibility, and they have to adhere to any guidelines relative to protected waterways, where it's a natural spring, natural waterway, whatever the body of water involves, they have to adhere to that, just like we do.
Now, you had this report done by Windsor Engineer.
Yes.
Stated that the subject property was not included in that. And that culvert from the point of Benefields to 7th and Laurel would have been inspected in that Windsor report?
The Windsor report did not include the private property of Miss Logan.
Yeah.
They were allowed to look at the culvert on the Benefields property.
For the Benefields approval.
Correct.
If Miss Logan had allowed the Windsor people to inspect that culvert, they would have done from start to finish, correct?
Correct. The report would be complete and they would be in a position to make some recommendations.
So we would know if there had been any obstruction between Benefield and 7th.
Correct.
Thank you.
Another thing, even though that starts on the Benefields property, it's assumed that it does not belong to the Benefields and was probably not put in by the Benefields, or do we know that? Pardon me, the people who owned the property prior to the Benefields at the time.
I have no awareness of who or when that was put in. I have staff members that have been on my team for more than 40 years. And that culvert existed to their awareness. When it was put in, we don't know.
And when we say property owner is responsible for that culvert, we're not talking about the Benefields, we're talking about the slogan. Is that correct?
Well, wherever the culvert resides on a private property, it is that private property's owner responsibility.
So we have two people who are responsible. The culvert looks like maybe less than 10 feet on the Benefields and the rest of it on other private property, including Miss Logan's.
Yes, I mean, we have documentation that the path going through Logan property has always been part of the path of that water coming from above Benefields, wherever it originates, Ecola Park, wherever that comes down. That is, her property is part of that path. It always has been, whether it was opened, closed, when that happened. That path existed for years. And that is what meets our city infrastructure.
Okay.
Okay.
And Karen, do you have emergency authority to go on to say the Benefields property if they're not, if the creek's totally backed up, or onto Logan's property, if it's backed up, you couldn't enter on for some emergency purpose to clear out the culvert for free flow of the stream?
Public Works does not enter private property, even during an emergency, without reaching out to the private property owner.
And you're ignored in perpetuity? We'll just let the water go wherever the water goes if you're ignored?
I would expect that if we had a situation where there was, public danger, public safety at risk, we could act under emergency to be able to address that. Water backing up would not come into that arena from my perspective. I would have to evaluate that, whatever the situation presented.
May I speak once more? I don't want to interrupt protocol, but before we close.
So we
Any other questions for me?
I got one. Was the Newton property included in the news report?
I don't believe so.
But the right of way between Newton and Laurel, along Laurel to.
All of the right of way was part of the report. Any of the city's property was part of that report. And then the specific culvert on the Benefield property was allowed to be reviewed.
I believe, Bill, we have a question here.
Yes.
I believe the opponent has asked to speak, but I know that the applicant always has a chance for rebuttal. If we wished to keep the record open long enough for the opponent to speak, we would still need to offer the applicant the final rebuttal, correct?
So this is a little bit of an unusual situation in that the applicant for the original permit is the opponent of the appeal.
Yes.
But in Oregon land use law, the applicant who is proposing to do something always bears the burden of proof. So they always should get the last word. So it is the opponent in this situation, but the applicant for the original permit should be the one who is allowed to have the last word.
Thanks, Bill. Ms. Logan, if you'd like to speak.
My neighbor, Tom Supley, had a meeting with Miss Labonte in her office where it was explained that the maintenance of the corner of that street was not going to be done anymore. Or if it was going to be minimally done. So I guess my question is, if you're going to take 54 acres of water and drain it down 7th Laurel, and then you're not going to keep the area clear for the water to traverse any further than the corner of the street, it's probably going to just start backing up, right?
follow what is allowed under the wetland provisions for maintenance
Okay.
period.
And I would like to just pass this map around, which is the map from the county that I am aware of my property and which I was aware of when I purchased my property. If you wouldn't mind taking a quick look at it, I would really very much appreciate it.
We'll need a copy for the record. Is that already been
That's fine.
entered into the
I
record?
think it was, I'm not sure.
Can I ask a question, Ms. Logan, while you're up?
I
Okay,
just left, so I think,
that's fine.
so this, as far as I know, is the last item being entered into the record. We've had a rebuttal. Is everyone ready for me to close the record?
I know Mike had a question. I also have a question for Ms. Logan. Is there any way that we can address our concerns?
Sure. So we'll keep the record open long enough. Ms. Logan, there are two questions from commissioners for you. If you wouldn't mind, please coming back up.
Yeah, this discussion over whether the stream is here or there seems irrelevant. Do you disagree? Do you agree with me that the stream runs through your property right now?
How is it irrelevant if that is the information that I received when I was looking to purchase my house? If I knew there was a culvert in the back of my, or coming from my neighbor's property and going through mine, I don't know if it's a stream or if it's a creek or if it's a place that floods on their property that has to go somewhere. I don't know that. How much am I supposed to investigate that before I purchase a property?
I'm not asking about when you bought. Right now, do we have any disagreement that that is stream 18?
Yes.
And on what basis? Do you think there's another stream out there that's, this is a stream that goes by another name, perhaps not 18?
I'm not even sure if it's a stream. It begins at 9th Street and between Ash and Ecola Park Road.
All
It
right.
has culverts running into it from every direction. Is that a
Thank you.
protected stream? If it's been changed course of?
It's in the code.
That's not for discussion right now. That's your question.
Yeah, thank you.
Jay, you had one question?
Have you ever had a culvert that's on your property inspected? Have you ever had the culvert, the waterway, right on your property? Have you ever had that inspected? You may have an entry from the Benefields, but you do have a storm grate on your property. Have you ever looked either direction or have someone look either direction?
It's completely clear. I have a video you can see down into between the grates.
Well, that's just one point. That's a small point. I mean, have you had it scoped from start?
I
along your property?
I had some other pipes, what do you call it, rotor rooted. And the same guy looked at that one, but he couldn't take the grate off. It's permanently on there. So I know I haven't
So
done
the answer is
that.
okay.
Okay,
That's awesome.
thank you. At this time, we'll be closing the record and moving to deliberation. Does anyone have opening thoughts or comments?
I think there has to be a discussion on where the stream is. We have two maps that I'm looking at right now. One is a national wetland inventory, but there's also a local wetland inventory. So there is some discretion between the two. Local runs right through the property, through Benefields, through Newtons. We know where it exits on the 7th. I think typically when we have this sort of thing that I've run into is that we get a wetland delineation and stream corridor information. And that would have cleared this up. And I would also have brought in the reason for one second, please. Triggered 17-116.
Yeah.
If it was outside of the stream corridor, outside of the 10-foot buffer, there would be no questions. But see, now we do not know that. We have to, I think by default, fall upon that.
I'm not sure why we do not know that. We know there's a stream 18, correct?
It's actually a tributary. The name, tributary
But it's
to Logan's Creek.
in the code as stream 8.
And it's under our local wetland.
And that is what the code, if you further up in the code, does identify that these streams from the local wetland inventory are regulated by this section of code.
17-116.
Right.
And even beyond that, in there, we would have had the wetland delineation, but then it would also have to come in front of DSL, Department of State Lands, and Army Corps of Engineers.
Right.
Whether they determine what their determination would be either that as part of it, or it would be a no permit required. So there would have been two steps that would have sort of followed, would have clarified what is actually happening here.
We can go down that path, and I certainly think Ms. Logan needs to have some, I don't know what kind of expert you have come in and verify what she needs to verify and tell us that there's not going to be a backup in that stream back into the Benefields property. But even if you assume that the stream ends right at that culvert, you take a 10-foot radius around that, and they can't build that curb on 5 feet either side of the stream anyway, or the culvert anyway. So the reality is they are asking to do something in the code under the riparian overlay that is not permitted use, is not conditional use. There's even an admission here that says the project we're trying to complete does not fall under any of these categories. That's almost an admission that they probably are with, that they are in the wrong. So I think really this is cut and dry. If you want to take the most restrictive definition of stream and have it end at that culvert, and I'll allow you to do it, you'd still have to have a big hole in that curb. I think the reality is, even with, as it is now, that stream is now flowing down its natural course over her property. That is part of the stream now. So she's actually proposing to put her fence in it.
Oh, was there?
Yeah. So I think it's pretty cut and dried, and we should support the application, but provide some guidance, or the appeal, but provide some guidance on what would be expected, for something like this to be considered by the planning commission and approved. That's my personal opinion.
I think that regardless, even if it stands how it is right now with the culvert, that's not the question of whether or not a 10-year event is going to back up onto somebody else's property, in this case, the Benefields property. I think the pertinent question before us is this new construction going to further channel water into other areas that it's not going into right now? Because we already have a backup on the Benefields, regardless of whether that dike or landscape fence is there or not. So I think the real question before us is, can we, with some certainty, say that this 3.5 foot retaining wall is going to divert water into areas and cause other unintended consequences? Because it's already backing up into the Benefields.
Correct. And as it backs up, it flows back onto a property just because
Right.
of the slope of the land. It's an interesting question, Steve. I think the reality is all we're required to do is apply the code, not resolve the equities of this thing. And the code is pretty clear to me that, she is within the buffer, potentially within the stream itself. She's asking for what amounts to a variance, almost. But provided no evidence other than the city screwed up and Mrs. Benefield's bad and everybody's bad, that, she's provided no evidence that she's, that conclusion is incorrect.
Yeah, I agree with Mike in that it's cut and dry in terms of the zone that she's proposing to work in. I don't see how, as laymen, without reports that would have been helpful from, various different professionals, if she would have provided them to us, maybe we could have more accurately assessed whether water would back up onto the Benefields property. I mean, again, as a non-hydrologic professional, I would say, yeah, if she builds this curb, dike, fence, whatever it is, it's likely to cause problems upstream. But she didn't provide any evidence other than her contractor saying, oh, we should just be allowed to do this. So I don't think it gets there. I think Mike hit the nail on the head, and the discussion's over at that point for me.
Les, do you have any comments?
Yeah, I think I do. I've struggled with this because what I know of the backstory, this is an unfortunate situation for pretty much everybody involved. My gut feeling, though, is that our stream corridor protection codes should rule. And to that degree, I agree with Mike. It's pretty obvious to me that they're working within the historical stream corridor. There are some things that I didn't see that would have made me feel better about it. How they're going to protect the existing culvert through this construction process. I even tried to do some simple math with elevations and adding 18 inches to it to see kind of where would the water go. And 18 inches above the mean grade is actually even higher than the street. I mean, conceivably, the water could be diverted right down the right of way or the street. I don't know. But I just know this is a difficult situation, and we're not going to solve the real problem. But I do agree that this application or this appeal should be upheld.
Thank you. Would anyone like to make a motion?
I move to vote.
One question before, this is just gonna be a cut and dried rejection, no conditions, okay. And maybe this is not appropriate for us. How would she solve her problem, or is that just beyond our scope?
That's not our scope. Our question is, should this application be reversed? And the reason it sounds like what I'm hearing here is that we all agree that this is in stream 18, and therefore the stream corridor provisions of 17.116 apply.
Okay.
And in that case, there needs to be a different development process.
Go ahead.
I move to a vote.
What would your position?
I move to approve the appeal.
And so this is where it gets tricky and we all screw up with.
Exactly.
You have to be pretty specific about how you, so the most, did you write it down?
I
think there is a draft decision. If you look at page.
Oh, yeah.
Yeah.
Staff report, there is some draft link.
Very brave to wade into this first meeting. It's always tough.
Do you have that, Robert, or?
I don't know if maybe I could, looking at the motion that Robert is pointing to, it kind of gives some options. And I think what you want to do is have a motion to reverse and hold the administrative decision to approve the development permit with regards to the Benefield appeal. So essentially you want to uphold the appeal, reverse the administrative decision, is what I've heard.
Okay, I move to reverse the development permit DP number 24-50.
And one more question. Do we want this to be tentative and look at findings first? Steve has a comment.
Yeah, I mean, if you'd like, oftentimes the plan commission makes a tentative decision. In this particular case, it's fairly straightforward. It might be one that staff would be able to complete with the work of the attorney and bring it back to the chairperson to sign. I would recommend that, but oftentimes you do make a tentative decision.
Let's do that.
Okay, so the tentative would come back to the chair. Is that-
What staff is recommending is that you make a decision to deny with staff to draft findings to have the chairperson sign the denial.
Okay.
Does that make sense, Bill?
Yes, there's sort of the two options. So what happens is there's got to be written findings and conclusions. Historically, if you go back 10, 15 years ago, what would happen is the planning commission would affirm or deny and then authorize the chair to sign the appropriate decision documents. 5, 6 years ago, I don't know the number, we kind of moved away from that a little bit because of some complex decisions and, the planning commission wanting to make sure we got it right. And what there would be a tentative decision, and the findings would come back to the whole planning commission to review and to edit. I think what I hear Steve saying is, and what I heard some of the discussion was, this is pretty cut and dried, straightforward in the planning commission's view, in which case it might make more sense to just vote to approve and authorize the planning commission chair to sign the appropriate documents, sort of reviewing what Steve did. And that way the planning commission doesn't have to have a special meeting to come back and review the findings. But if the planning commission does want to see the findings, that's certainly something we can do as well.
Okay, so I'm hearing everyone is happy with having the chair sign the findings.
Yeah.
I think you can finally read your motion.
Okay. I move to reverse the permit, the development permit DP number 24-50 with regard to the Benefield Appeal Application AA number 24-01.
I second.
Okay, Tessa, would you please call the roll?
Commissioner Sinclair,
Yes.
Commissioner Waite,
Yes.
Commissioner Orloff, Commissioner Bates.
Yes.
Commissioner Matusik,
Yes.
Vice Chair Moritz.
Yes. Appeal is upheld. And permit is this item. Vice Chair back.
Comes back.
Our next, Mickey, would you like to keep the chair or would you like me to?
You may
Okay,
finish.
all right. Thank you. Our next item are informational items. May we have the tree report, please?
Yes. During the month of December, a total of 6 trees were removed, 4 of which were dead, 2 were hazard trees, and there was a replanting requirement of 5.
Okay, questions about the tree report?
No.
Nope.
We'll move to the good of the order. Does anyone have any items for the good of the order?
No.
No.
Mine? No? Okay, then we will adjourn.
The order is good.
Exactly.
Everyone, good night.
Right.